get you scheduled, I think, for the 14th of December, okay? Good afternoon, this is Judge Alyssa Perez, resuming the criminal docket for the district court for December 7th, 2021. And all matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we're streaming all matters live via YouTube for public viewing. We are back on the record in state of Texas versus Refugio Rios, having allowed counsel some time to discuss a new rec with ADA Flores, and having had time to speak with her client. Ms. Butterworth, do you waive your bond hearing today?
We do, Judge. We would like to, I've talked to Mr. Flores. He's going to send us some plea paperwork on the felony case that's outstanding. And we have also hopefully come to an agreement as far as the revocation goes on the 2016 case. We would like, if it's okay with the court, for my client to be modified on that probation to BHRTC. So hopefully, I don't know how that works, but if he could get on that waiting list, or we could start that since he's been in custody for a while. But that will be how that older case will be resolved as well, Judge.
Has he been to treatment before, something on the level of BHRTC?
I don't remember that answer, Mr. Rios. Can you tell us what treatment you've been provided so far?
CRTC, but it was in 1999.
Okay.
This is the first revocation, Your Honor, or motion filed on this case, so I don't think he's ever been modified. Mental health or BHRTC.
And I think, Carla, what would you need in terms of modifying him to BHRTC? Does he need to sign off on some documentation?
Yes, Judge. So okay, let me kind of rephrase this. The pending charges, he's not going to get probation on those, correct?
That is correct.
Okay, so then it would just be the probation matter. So yes, I would need for him to sign off on the consent form along with his modifications in order to get him on the waiting list. I'm not sure if we want to do this right now or wait till next week.
I think we should, if we can do it now, that's great, because that's what I was going to ask, if we can get the assistance of Ms. Butterworth to get him signed up. But if we can do it now, great. I'm not seeing anything in the case summary that tells me, he's been through BHRTC before or anything. It's just some other kind of treatment.
It's just been outpatient.
I'm good with the agreement. So let's just get him squared away with signing off on the paperwork to modify him, and we'll have him back on the 14th for a plea at 3 p.m. Anything else?
Nothing from the defense, Your Honor. Thank you very much.
Nothing from the state, Your Honor.
Right, you all are good to go. Thank you.
Thank
Who's
you,
next,
Judge.
Chewy?
Thank you.
Hey, Judge Ramsey. Annex, if we can get Silvia Ramsey, please.
Yes, sir.
Thank you, partner.
Go ahead.
Okay, Judge. It's cause number 2020-0D04156, State of Texas versus Silvia Cecilia Ramsey. Announcement of counsel, please.
Josh Avila and Renee Flores for the state, Your Honor. State ready.
And Daniel Avilar for Silvia Ramsey. Good afternoon, Judge.
Good afternoon. Ms. Ramsey is appearing from the jail annex. We were at residential treatment for Ms. Ramsey, if memory serves. So that's where I am. Do we have her squared away? Mr. Avilar, have you talked to your client?
We do not have her squared away, Your Honor, but I have talked to her, Judge.
Okay, well, that's basically where I am, Ms. Ramsey. I'm not sure what the holdup is. Mr. Avilar is wanting to speak, and is there something, are you good with that?
She can talk. I think she has a plan B, Your Honor.
Hi, Your Honor. Good afternoon.
Good afternoon.
I would like not to go to BRTC and do my state time, Your Honor. I am in a program right now here in jail, and it's a really good program. I feel confident in the program, and I just don't see any benefits to going BRTC. I've heard really bad stuff about it, and I would rather just do my time here or state time and continue with my program.
What's the alternate time rec?
If I remember correctly, Your Honor, it was 2 TDC. I'm trying to see, was there any restitution order in this case?
No.
Probation, court costs, fine, restitution. I don't see anything on restitution.
No, I didn't see any restitution, Your Honor, so I'm okay
All
with
right.
two TDC.
So that sounds like an agreement. We will bring you back on the 14th of December, Ms. Ramsey, if we can get that paperwork circulated, Mr. Avalar, 3 p.m., okay?
Judge, is the 14th a Tuesday?
Yes, I
Okay.
think so. I've been saying it all. Oh,
Um,
it's the 13th. It's the 13th, right?
Well, I'm asking because
Hold on.
No, December 14th.
Oh, it's the
is a
14th,
Tuesday.
the 14th. Hi, Mr. Avalar.
but is it I think that's a Tuesday. I'm asking because I'm picking a jury on, thank you. I'm picking a jury on Thursday, the 16th, right? Yeah. So
Oh.
I think we can do it.
Yeah, you can do it.
I can do it.
Yeah. All right, we'll see you then.
Thank you, Your Honor.
you. Okay.
Good luck to you, ma'am. We'll see you on.
Yeah, just send the paper. Hey, Josh, if you can send me the paperwork sooner rather than later, because I'm
Yes,
worried about
I will
my
do.
trial. Okay, thank you so
That's
much.
fine.
Appreciate it.
Wait, when are you traveling out?
My it's in New Mexico and it's on Thursday.
Okay, copy. I'll send it to you today or tomorrow.
Yeah, it should be okay. Miss Ramsey, we'll talk soon, okay?
Thank you.
Thank
Thank
you.
you. Who's next, Sri?
The bias annex, if we could get Daniel Bias, please.
Yes, sir.
Thank you, sir.
Go ahead, Sri. Oh, he's not there yet.
And Judge, can I be excused?
Yes, thank you, Mr. Avalar.
Thanks. I'll see you soon. Bye.
Take care. Bye. Go ahead, Sri.
Okay, Judge. It's cause number 2019-020-4292, State of Texas versus Daniel Bias. Announcement of council, please.
Josh Avila and Renee Flores for the state, Your Honor. State ready?
And Scott Ferguson for the state as well, Your Honor.
Okay, we're scheduled for a status conference today. Mr. Vias is appearing from the jail annex. We are scheduled for trial in February of 2022. What is an update on this one?
Judge, we are still working from our end, reading paperwork and working on the case. We are open to try to resolve it. We're just hoping to reduce the wreck sum.
What's the rec, Mr. Ferguson?
Your Honor, let me see. Josh, are you familiar with what the last wreck was?
The last wreck was 40.
40,
Right.
right. The 40 was actually, now that I think about it, has been the one and only rec in this case.
Yeah.
I know there was previous counsel. In this case, there was negotiations,
True.
but now we have new counsel.
Mhm.
I've been unaware of any counteroffers from Mr. Ronell or any conversations on that end, but for now, I believe the recommendation is 40.
So look, this is my concern here. It's another murder. We've had 3 defense attorneys on this case, and you are set for trial in February. I have not seen anything other than some state notices with respect to Mr. Vias. I don't know if he worked at Walmart, went to school. I think those were filed back in October 2nd. We've gone beyond deadlines, but I basically have seen nothing happen in this case since then. We had a trial setting, I believe, in early October. It might have been October 1st, but we had our backup date of February. What I'm here to let you know is that case will go in February. I have your panels and it is going to go. So none of this dropping the ball and I'm late in the game and I didn't know this was happening. We are going to trial in February. There's been no movement, 0 movement. He had a public defender, then he had Ms. Caballero, now he has Mr. Darnell. The record's never changed. Nothing has ever happened that I can see on this case, other than I think he got reviewed for competency. So I'm letting you all know, I don't want to hear all the same old story. Okay, we're going to trial. I am attempting to confirm 4 panels for this case. He's been in jail 907 days. Okay, letting you all know that. Is there
Your
anything
Honor-
outstanding? Yes, sir.
And just so we know, because I know we had previous counsel and I know we had some discovery things to do with Ms. Caballero. Just so we know, Ryan, we can clarify on the record with Mr. Darnell, are there any discovery issues that we have right now that you can have us either work on it right now or put it on the record?
Not aware of any at this point.
Copy. Okay. That's it, Your Honor.
So what I can tell you is back in 2020, March of 2020, Defense Counsel had filed motions to suppress. I don't know if those need to be heard or not, but I do not want to wait until, the final hearing plea deadline in February to say, hold on a second. I don't have such and such evidence from the state. I need a hearing on the suppression because this case will go in February. Okay.
Yes, Your Honor.
Thank you
Very
very
good,
much.
Your Honor.
Well, and let me ask another thing. Mr. Ferguson, are you,
Yes.
counsel, are you the one that we're going to on this case? I don't want any more back and forth with, multiple prosecutors handling it and we didn't know what was going on. Are you the point of contact?
I am the point of contact. I do not
Okay.
know if I will be medically cleared to actually try it in February. I may
But
have
you'll
to
be
have
working it.
somebody else try it, but I will be making
Working.
sure everything has been done.
Okay, all
Your Honor,
righty.
this is Renee Flores. I'll give Mr. Darnell a call regarding this matter. I believe we'll be able to work something out. If Mr. Ferguson is not cleared, I'll be on this case, Your Honor.
Okay, and we actually do not have another setting until that final hearing plea deadline. That's not gonna cut it for me. We're gonna have to have a status January 11th at 3 p.m. Mr. Ferguson or Mr. Avila or Mr. Flores, has anyone been in contact with the decedent's family regarding the trial, all of that?
Our victim advocate has, Your Honor. They recently contacted, they're actually watching, it's my understanding that they're watching the proceedings right now. They have been in contact with their office almost on a monthly basis.
Okay, all righty, so they're in the loop. All right, just making sure. If we become aware of any conflicts, witnesses, issues like that for trial, I want to hear them in January. So start making calls and finding out what you're doing if we're not going to resolve this, okay?
Very good, Your Honor.
Thank you,
Yes,
gentlemen.
ma'am.
Thank you very much. Thank you, Mr. Valles.
Thank
Who's
you, Your
next?
Honor. Give me a call, Jim, if you wouldn't mind.
Okey doke.
Thank you.
Who's next, Truth?
Okay, Judge Nelson. Page 7.
Okay.
Annex, if we can get Clevy Nelson, please. Thanks, Mark.
Okay. And give me a second because it is way too warm in this office.
Yes, ma'am.
All right, we can get started now. Oh.
Yes, Judge. It's cause number 2021-0D0-2380. State of Texas versus Clevy Nelson. Announcement, counsel, please.
Your Honor, John Briggs, Michelle Hill, and Haban Mohammed for the state of Texas. The state is ready.
Brock Benjamin, on behalf of Ms. Nelson, as the court observed a while ago, Mr. Lopez will be joining us and smiling the whole time. He has been on the case since the beginning, but he will be here for trial, and he had to drop off and go to another court, Your Honor. But he will be here Thursday.
Okay, all right. Right, final hearing plea deadline. Does anyone have a rec?
Yes, Your Honor. And I received a new one today. And I guess if I could take the easiest item first, Your Honor, I have contacted.
No. Hold on. I want to hear from the state what the rec is.
Your Honor, made Mr. Benjamin a recommendation of 10 TDC on manslaughter with a deadly weapon finding.
Okay, all righty. And Mr. Benjamin? Are you
Yes,
taking the rec or not?
I'm sorry?
Is your client taking the rec or no?
I haven't had the opportunity to communicate that to my client, Your Honor. I spent 3 hours with my client this morning, and John Briggs's timing was horrible and called me in the car on the way home. So I explained that to Mr. Briggs, Your Honor, and it's not his fault. And so I have reached out to the jail and set up a Zoom for this evening, Your Honor. And I was going to, in an effort to attempt to make sure that I could resolve this, if this is possible, Your Honor, I was going to ask the court for permission to conduct a Zoom with my client and my client's mother so that I would have all the decision makers in one area on Zoom. I have put in play that with the jail, Your Honor.
Okay.
I'm just looking for the court's permission to essentially include the third wheel, so to speak. I think that would be helpful.
Oh, I'm not trying to pressure, and I wouldn't hold you to it, but I received 3 affidavits that I have not had a chance to look at. If it helps expedite things, I'm not telling you you have to resolve it today. I can take a 10-minute break if you want to talk to your client. And no, that's not enough. Okay, you don't have to do
Your
it.
Honor, 10 minutes won't get me there. The reason it's being done at 5 o'clock is because I'll be done with any other matters, and I will have the jail is very
Okay, that's fine. That's fine.
Judge,
Go ahead.
if I could, I don't want to interrupt. I'm sorry, but
Go ahead.
Mr. Benjamin, when you're going to talk to your client this evening, I have heard back from Mr. Wyatt. I'm sorry.
I did too.
Okay. Well, I just
go
wanted
ahead.
to
I didn't mean to cut you off, sir. Go ahead. I'm sorry.
That's okay. I just wanted to make you aware we have reached a deal with Mr. Senesi and for a plea, and that plea does include his testimony in a trial if we're going to have a trial starting on Thursday.
Okay, Chewy, who has the jail docket tomorrow morning? There should be 2 courts, or if the attorneys know who has the jail docket tomorrow morning.
Judge, if I'm not mistaken, it seems to me that Judge Solis, I think in the 243rd, we used to do Tuesday and Wednesday stuff. Maybe she's Monday and Tuesday. I could be wrong about that, Judge.
Let me see if I can find out, Judge.
Okay, see what you can find out. In the meantime, okay, so there's a lot of different ingredients in this pot right now, but to the extent we can address some other things, I can tell you I haven't had time yet to look at those affidavits. And there are 3-4 pages each investigator. I think I kind of looked them over, and generally we're talking about contacts made after November 18th. So I'm not sure that gets me where I need to be if you want me to reconsider the motion for continuance. But what do you want to take up first, Brock, since you were taking the lead on that one?
Your Honor, I'm just asking the court. I mean, do I have the court's permission to include a third week to include the mother on a Zoom? I think it would just make the jail more comfortable if I could do that. She won't be here. She's actually going to be with me, I think. Thank you, Your Honor.
Okay.
Can I start down the list, Your Honor? Or does the court have a order that it'd like to go in?
No, you can take the lead, Mr. Benjamin, and we'll see how we go from there.
Your Honor, I guess the first thing I would take up specifically because Mr. Senesi is going to be testifying is I had proposed an order to the government in response to the court's issuance of that order for Brady to be provided, and the court's order was to provide Brady today. That raises an interesting question with Mr. Senesi that, and I'm going to phrase it this way, Your Honor, because this is the way I see the world. They waited until the nth hour to make him an offer he couldn't refuse. He made the offer, but I haven't received any Brady or prepped on Mr. Senesi. And so, Your Honor, I mean, essentially I would ask to exclude that type of issue because I mean, we're here today and I don't think I'll get it even in the next 7 hours is my guess.
Right. I completely agree that you should exclude any evidence of any deal that we have with Mr. Senesi.
I was going for the required disclosures under Brady. And so, because if there's no required disclosures, there's no Senesi.
Well, I disagree with that. And actually, the discussion that I had with Mr. Wyatt, I wasn't notified until about 15 minutes before our hearing was scheduled today by text that he was going to reach our offer, which was verbal. It's not been reduced to writing yet. No one has signed anything yet. So I'm giving you the courtesy of telling you that it's coming. And as soon as I have it and it becomes Brady, I will send it to you. But I can't send it to you before I have it. So I will be happy to comply with the court's Brady order just as soon as I get things. I can't give you what I don't have.
And Your Honor, I have to say, I discussed the matter with, I started the discussions with Mr. Wyatt over a month ago. So this isn't the 11th hour. So
Well, that's okay. Because, there's always all these moving parts, then for my purposes, notice, as soon as we have that formalized, then whatever notice pertains to that has to be disclosed by end of day tomorrow. Okay.
Judge, he is, my understanding, he's going to be in our office tomorrow to talk. And so
I forget he's out. Yeah.
I think that by end of the day tomorrow, we can definitely comply with that.
Okay. All righty. What's next?
I guess just on the Brady issue, Your Honor, any other Brady material, the court, I don't know if the court had signed that order or that it had talked about and I'd proposed on Monday.
I think I sent them out maybe Sunday night, so they should, if they're not reflected in Odyssey, they should be going. I was having some trouble with being able to forward e-signatures. Does anybody see those? I'm not on Odyssey.
And Your Honor, I understand I had to reset all my emails over the weekend for some unknown reason. Your Honor, discovery. It's my understanding, and we were exchanging emails late last night, and for some reason, the portal was turned off, and then Mr. Briggs assisted me in turning it back on. When he turned it back on, there was 1,300 new videos that showed up on my portal. Those videos
1,300 new videos?
1,300 videos, Your Honor. And then I sent an email to Mr. Briggs, who was working later than I was last night, Your Honor, and told me that we are also, or that not we, that was his word, we are also dumping or extracting information from 2 cell phones and a computer. And so I raised that, Your Honor, because I'm prepping for diaring right now. I'm not discovery reviewing. And so to the extent that those are going to be used, and I don't know what's planning on being used or where we're at, I have some concerns about disclosure. And I went back, I've looked at some things, and everybody kept saying that everything was being disclosed and everything had been disclosed. And I ordered 2 transcripts, Your Honor. And so I don't know where the court, that puts us with that for the court.
Well, so what you're telling me is you're objecting to all this new dump of all this new evidence that they're finding because now they're working the case, right? That's what you're telling me.
That's a summation, Your Honor. Yes.
Okay. Well,
Judge, if I can speak to that, I also have discovery concerns here. I will, for the record here, I want to put a little bit of stuff on the record for historical purposes because I anticipate this case lingering around for some time post-conviction. And I want some things to be clear that this case was not being handled by the homicide units of the DA's office here until, well, it wasn't even being handled by. In November, in the early part of November, early to mid-November timeframe, Michelle Hill and Haban Mohammed were asked to get on the case with Mr. Cox. That happened right before the 3 of us were scheduled to go to a homicide conference in the Dallas area.
Mr. Price, let me stop you right there. Who asked? Was it Mr. Cox that asked Miss Hill and Miss Mohammed to join?
Yes. Yes. Okay. I don't think it was Mr. Ferguson. It could have been either one of the 2. I believe it was Mr. Cox that requested that Miss Hill and Miss Mohammed get on the case. We left on November 16th for that conference and didn't return until Friday the 19th late. And so Miss Hill and Miss Mohammed really didn't jump into the case until I suppose that following, we knew before we left that they were going to be asked. And I know that if you look at the affidavits that we've given the court from the investigators, you wanted more detail about what our investigators had been doing to locate these witnesses, because that was the basis that we were asking for the continuance when we met late last week. I'm not going to hash that. The affidavits are there for the court to read. And I think they detail kind of what started happening on the case at that point. Now, I will completely acknowledge that our getting on this case and jumping into it probably, after November, 16th, doesn't excuse the fact that things weren't done on this case the entire time that it's been filed. And my understanding was that, the offense happened in October of 2020. The case was filed initially in a 2020 cause number, so I know it was indicted before the end of the year. And it doesn't appear that much happened with the case in our office for the remainder of 2020, nor the early part of 2021. I know that there was an indictment towards, I think it was in September, a re-indictment, Judge. The court will know better. The file speaks for itself on that date. I believe it was re-indicted right before trial. The state ended up asking for a continuance, having re-indicted right before trial. We asked for continuance. It was based on not being able to get the witnesses we needed, and the court granted that continuance. That was long before Ms. Hill and Ms. Mohammed and even I got involved in this case. And I know that the court, I believe we talked about this last week, the court set us for trial day after tomorrow on Thursday, either at the very end of September, very beginning of October. So we were given basically 2 months from the time that the court granted the continuance to when the case was reset. Ms. Hill and Ms. Mohammed didn't come on the case until we were probably about 3 weeks from trial, something like that, maybe 4 weeks at the most. Okay. I know, because I've been assisting them, that they have been doing everything they can to get this case ready to try and meet the court's jury setting on the 9th. The affidavits from the investigators speak to the efforts we've made to try and get these witnesses and secure their attendance. We've actually had some success in that respect. But I have to tell you, what concerns me the most is that in preparing this case and getting into this case and speaking to Ms. Hill and Ms. Mohammed about it, what is concerning me the most is the fact that there is a laptop that belonged to the victim in this case that was collected by the police. And the police never did anything to retrieve the information off of it in the entire time that it's been in their possession, nor did the state of Texas, Your Honor, during the pendency of this case, request that information get taken from that computer and we see what's on there. That didn't happen until I believe it was yesterday that we discovered that had never been done, and started raising the alarm with the police and telling them, give us that information. We got to have what's on that computer. Okay.
Let me ask you on that, Mr. Briggs, on that laptop, was it otherwise identifiable? For example, was it in your list of evidence?
Yes.
Okay.
Yes.
Okay. Go ahead.
Completely. It's been listed in our file from the get-go. And so the state was aware of it, even though we didn't do anything with it prior to our getting involved in the case. And Mr. Benjamin, I don't want to speak for him. I know that information has been contained in our file from the inception of this case. That computer is listed as having been collected. The other two items that were listed in the same fashion from the beginning, Judge, is the cell phone belonging to Mr. Benjamin's client, Ms. Nelson, and then also a cell phone belonging to co-defendant Richard Senesi. And I'm not going to make excuses. Cops didn't download it. The state didn't download it. And it wasn't until, the Ms. Hill and Ms. Mohammed got into this case and we started prepping for your trial setting day after tomorrow that we realized those phones haven't been downloaded either. Okay. Now, the reason that causes me concern is that, you know, our job in the penal code, or I'm sorry, in the code of criminal procedures is to see that justice is done. Okay. I don't feel like in good conscience that I can go to trial on a case that I don't really know what the evidence is. Okay. And I've got to believe that the stuff that's going to be on the victim's computer, which the indications are, was linked to his phone, which was destroyed in the fire when he crashed. The computer is linked to his phone and to his Apple Watch. And so I think we have his text messages from his phone are on that computer. Text messages potentially between him and Clevy Nelson. I don't know that there are any. Well, I take that back, Judge, because the detective that we talked to yesterday powered up the computer, found some text messages, videotaped his scrolling through those messages, and that video is supposed to be being uploaded to the portal here anytime. Okay. And yes, Judge, I realize that's absolutely last minute, but that's when we got on the case and started doing this stuff. I can't do any better than that. Okay. And Judge, I know you're going to tell me that doesn't excuse us not doing anything for the last year and 3 months, and you're absolutely right. Okay. But I can only talk about what we are trying to do since we've been on the case, which is everything possible. Okay. I don't think that in good conscience, I'd be doing justice going to trial without knowing what all the evidence is in the case. And, you know, if this were, you know, an insignificant piece of evidence or something, I might be able to say, okay, I don't need to know exactly how that fits in this puzzle that is my case. But when we're talking about electronic devices, which contain people's lives nowadays, I feel like we need to go on there. And here's the problem. I don't think that, well, if we go to trial on Thursday, Judge, and I don't know what's on that laptop, and I don't know what's on those two phones, and I haven't disclosed it to Mr. Benjamin, and even if the court were to somehow say, Mr. Briggs, you all dropped the ball so badly on this and you waited so long, I'm excluding that evidence. You don't get to use it. I'm not sure if that's legally appropriate. Maybe it is. I like to try to not tell judges you can't do something because that never goes well. So the problem here is that now Mr. Benjamin and the state are going to trial without knowing what's on those devices. And in my mind, that is only going to cause problems, because in the event that we get Miss Nelson convicted, Mr. Benjamin will be accused of being ineffective for going to trial without knowing what was on the laptop and the cell phones, especially if after we get that information back, if there's anything even remotely beneficial for Miss Nelson. Okay. If there is something beneficial on there, I'm obligated to turn that over to him even after a trial where we get her convicted. And what's going to happen then? Now he's going to get an automatic new trial, because now there's exculpatory evidence that I didn't find until after the trial was over because we just didn't have time. And now I turn it over to him and he's getting a new trial. So Mr. Benjamin is actually kind of in a good position here, because if he continues to scream that I want to go to trial, I want to go to trial, I want to go to trial, worst case scenario, his client gets convicted and then he gets an automatic new trial, because anybody coming in after the fact is going to say he's ineffective for going to trial without looking at that stuff. And or if there's anything even remotely Brady, which I don't like to predict the future, but I don't think that everything we're going to find on those three devices is going to be all, you know, roses and sunshine for the state. And anything I turn over to Mr. Benjamin is going to cause a new trial after the fact. We go to trial on Thursday on this case and get a conviction, I guarantee you we're coming back to try this thing again. Okay. So I'm not attempting to use, you know, Mr. Benjamin's, you know, right to discovery and all that to try and delay this thing. But Judge, I don't think I'm doing justice to my oath to see that justice is done going to trial when I've got three very important pieces of evidence that I still don't know what's on there. Now, I granted, Judge, you're right. It's my own fault being the state, because we didn't get to it sooner, and I acknowledge that. But we're in the position we're in, and I can't do anything about that. Okay. So I do have concerns about that. With regard to these 1,300 videos, went did a little looking, Judge, and what happened is I will tell you that I did get the call from Mr. Benjamin yesterday, I believe, that he was not able to access his client's case in the portal. Normally that falls on the side of the page dedicated to not my problem because I don't do tech stuff. But I went to our portal people and I said, hey, Mr. Benjamin's saying he can't get into this case and it's a murder case and he needs in. We're going to trial on Thursday, so figure this out. It turns out that what the portal is telling us is that he was not registered yet in the new cause number. And I can tell this to the court for certain is the 1,300 videos that are there now. I haven't counted them. I'm going to take his word. It's 1,300. It's 14 pages in the portal with about 30 videos on each page, more or less, I'm guessing. So whatever that comes out to. Those videos have been in the case since October. I think they were put in there around the time of the reindictment or before the reindictment and the continuance, because those videos show that they've been in there, the same videos that were in the old cause number. It's the same videos that are in the new cause number, and those videos have been in the file for some time. I think since before the reindictment, obviously, because they're pulled up in the old portal cause number. So those 1,300 videos are not new. Those have been there since before the reindictment. So, Judge, the problem is, look, I get it. The court is not happy that the state is not ready. Okay, I get it. And if I were the judge, I'd probably feel exactly the same way. So I get it. We dropped the ball on this case. And it wasn't until we got into the case here a few weeks ago that we've been giving it the attention that it should have been getting the whole time. But the bottom line is, we haven't had enough time to do it the justice that I would like for it to get. If we're going to go to trial on Thursday, we're going to go to trial on Thursday. I'm telling you, sure as I'm sitting here, if that ends in a conviction, we're coming back for a new trial. And we will have wasted all of this time. So, Judge, I do hope the court will reconsider our motion for continuance. I don't want a long one. I'm very cognizant of the fact that Ms. Nelson has been in jail now for over a year. I do not want her sitting needlessly in jail. I don't want a long continuance, but to do justice in this case, we need the time to get these items, resolved. I need to get the information off these phones. I need to get it to Mr. Benjamin. We need to look and see what's there. I don't know if that's going to impact our ability to resolve this case without having to have a trial. So, you were talking earlier about there being a lot of moving parts. Yeah. We've had to, in the last day, go approach Mr. Senesi to see if we can resolve his case and do that in a way that we can, use him in our upcoming trial against Ms. Nelson. I can't give Mr. Benjamin any more notice than I did because it's happening last minute because, Judge, that's all I've got is last minute. Okay.
All right. So, Mr. Benjamin, what's your, is that all you have? I mean, I get it. Anything else on that? Mr. Benjamin, what's your take on that?
Judge, up until the last 30 seconds, I was with Mr. Briggs when he was going to agree to a straight PR bond, because that's where we're at, Your Honor. They have pushed and fought tooth and nail and
Judge, if I can, I'm sorry.
I don't want to hear about the bond right now. Yet. I know we're scheduled for that today. What I want to know is, based on everything that I'm hearing, we have a laptop maybe full of information. We have cell phones, and not knowing those things, where are you on that and the continuance?
Your Honor, I think it was last Friday when we came in front of the court, I told the court that I have a witness that I cannot get served. She has specific, the state's aware of this person. I gave them, well, actually not the three that are on here, but I filed documents with her name and essentially provided what I titled a 404B notice. She's a witness who I would love to have here because she's a necessary and material witness. I need to send my client physically to Houston to go talk to her because she has dodged an investigator since mid-October. So, Your Honor, I can't separate Mr. Briggs. I'd like to have all of this information and everything else and run that at the same time with what he's telling the court, which is we need to have time to review all this evidence and do all these things. I agree. I would love to have everything in a much better world, but as it stands right now, my client has been in custody, and my client, and I've told the court I'm going to have a long chat with my client, and that's what I like to do after hours. But my client has told me that she wants her day in court. And so I am not the person that has put us in this position. Realistically, I agree. John Briggs is not either, but the state has, and the state is fighting us tooth and nail. And so I can't separate those two realistically, Your Honor.
Judge, if I could just jump in there.
Wait a minute.
really
I
quick.
guess what I want to know from you, Mr. Benjamin, is with all this new information, right? Unknown, maybe, are you still opposed to a continuance? And I don't mean because if your client's not in custody, then you're more amenable to a continuance. I mean, literally on what we know now in terms of what the state has disclosed, are you still asking to go forward on Thursday?
Your Honor, I need to discuss Mr. Senesi. He's the only thing that's moved my needle. And Your Honor, for the record, so that everybody understands the way I've been treating this, last Thursday when I got the offer from John Briggs, I went out after hours and talked to my client for, I don't know how long after hours. And then we had the hearing on Friday morning. Yesterday, I had the essentially text messages with Wyatt. I drove out I had 3 hours of trial prep with my client in the morning. I went out, I talked to my client again last night, and I went out and talked to my client again this morning. And what has changed materially since then is that Senesi is on board, because he was not as of when I talked to them this morning. And so I think, quite frankly, Your Honor, that's a call that the client makes. I am not in a position, and I don't believe legally or ethically I'm in a position to say that. But Senesi is the item that is moving my client materially. And Your Honor, respectfully, I don't think I can separate those all. And so the issue, though, is, in my opinion, the fighting tooth and nail. And Your Honor, I'm not going to misrepresent something to the court that, yes, if a client's out, we continue things for a long time. That's a standard issue that we do all the time, because if a client is in custody.
Wait, what did you just say? If the client's out, what?
That cases are continued and treated differently. They're not at the front of the docket, Your Honor.
Okay, go ahead.
I mean, and that's how I get to the front of the docket, is because my client's in custody. My client's been in custody for 15 months or 14 months, I think. I'm coming up with math one of these days, Your Honor. And so
Okay. What else? Okay. What else? Mr. Briggs, do you have anything else?
Well,
Before we
Judge,
get to the bond hearing?
I know that you had planned to take up the bond issue today, and I mean, we're essentially dealing with that right now. I think I just want to make the court aware that, where the bond is going to be concerned, what's the only thing that's changed since the last time the judge visited the bond issue is actually her situation is now worse, in the sense that she's no longer part of the Army. When I'm not going to belabor all of the stuff that you've heard, we've had a bunch of bond hearings on this. I know you're familiar with her and the situation before. When she was here in front of the court for a bond, she was still part of the Army, and had she been able to make bond and get out, we had the added kind of help that comes with her being involved with the Army. The Army can order her to do certain things and make her appear and kind of help us keep tabs on her. And since the last time the court visited the bond, things have only gotten worse for her in that respect, because she's been separated from the Army. She now has virtually no ties here to the community. The big tie she had was that if she got out, she was still in the military and she was stationed here. And I guess her mother may live here. I don't want to represent that she doesn't have any ties, but the biggie was that the military still had control over her, and that's no longer the case. So, Judge, as the state of Texas, I have to oppose her being allowed out on bond, given the seriousness of the charges and that sort of thing. All the things that you've heard and considered, and that the court, I'm not going to belabor any of that. So, as the prosecutor on the case, I have to take that position. The court obviously can do whatever the court feels is necessary, and if there's some equity that has to be reached there, then obviously that's a matter that's up to the court's discretion.
Mr. Benjamin?
Your Honor, my client is not legally out of the Army as of today, is my understanding. And she will be out, I believe, sometime in the next 15 days or so is what I understand. But we heard over and over again that the Army wasn't sufficient or anything else. Your Honor, there has been no evidence presented that Mrs. Nelson is a flight risk. She's never been charged with a crime before in her life. And the case does get essentially better and better. It's now they have Tennessee, but that's a cooperator, Your Honor. And so I can go into the other factors the court's looked at before. If the court had some questions, her mom is here. Her mom's involved, and has multiple ties. They've lived here for a couple of years now. I'm not sure what else. When you become a resident of the community, if living here and having ties here.
So is the state opposed to any reduction in the bond, or just the pure PR bond?
Judge, I have to be completely honest with you. I don't know what the current level of the bond is. We've done this so many times. I haven't been involved in it, but I know that we've had so many bond hearings. I'm not sure that I know what the bond is right at this moment.
I don't want to misspeak, but I know we talked about it last time. Let me pull it up. Go
May
ahead.
I, Your Honor? It's $250,000 split, $125,000 cash corporate surety. The issue, Your Honor, and I submitted an affidavit to the court to the effect and back in October. My client has the cash for the 10%. She sold her house to pay for her legal fees. And so I'm not sure what more, you traded essentially your ability to get out of jail and your property that was going to be the anchor for your ability to have your defense. And so she is being confined by the requirement because she doesn't have $125,000 cash.
Hold on a second, Brock. Is it Mr. Hinojos? Are you here? I'm sorry, Ms. Shafino. Can you email me the current bond order, please? I'm seeing one that's higher, and I know it's not the last one. Okay, go ahead. Who is speaking?
Well, Judge, murder obviously is a serious allegation. Anytime someone's charged with that, the safety of our community, I think, is an issue that needs to be concerned. So it's not something we can treat lightly, but I am cognizant of the fact that she's been in jail for a very long time. And I am cognizant of the fact that the state hasn't been as diligent as it could have been on these cases, although we're trying to rectify that. So, and I'm going to take Mr. Benjamin at his word. I don't have any reason not to about, the status of her finances. So that being the case, am I opposed to a reduction? Well, Judge, I just want the bond to be sufficient for us to be able to complete this undertaking, and that it reflect, the seriousness of the charges and the potential danger that poses to our community. And I'm not talking about she's got a huge criminal background or something like that. That's not the case, but murder is the biggie, and it might be the only thing you've got, but it tells me something about you and whether or not I want to be, living right next door to you or something. So, those are the issues. You do this all the time, Judge. You know what the issues are in bonds. So I just want the bond to be sufficiently high that it is meaningful, that someone is going to be out a large chunk of money or a piece of property or something in the event that she does decide to flee. So, Judge, I guess I'm not opposed to somewhat of a reduction, but the bond does need to be appropriate for the offense, I think.
So I'm showing a corporate surety cash portion of 150,000, and then the PR is 100,000. Okay.
Judge, maybe if can I make a suggestion?
Mhm.
Like number suggestion? I think that under the circumstances and given her history and kind of the problems on the state side of things that I'm trying to take responsibility for and kind of balance some things here, maybe 75 is the way to do it. 75,000 and cash or surety 75,000, PRB 150 total, but that would be some relief, I think, on the cash or surety portion, and yet it's still a big enough number that someone's going to want to have something worth that to hold it. So that might be appropriate, but I don't want to try and tell the court what the court should do.
Your Honor, and I appreciate Mr. Briggs's offer, but the issue is going to be the same whether if the court makes the bond any amount over essentially about $20,000 cash, because she can post the $20,000 cash, but the issue is there is no legal property. And so this is an interesting issue, and it doesn't exist in New Mexico. New Mexico did away with cash or corporate surety bonds because you're detaining people who do not have property. And so that is, for the record, Your Honor, that's my issue. It's not $150,000, $200,000 PR bond and a $20,000 to the court for the court's registry. I take issue with the fact that the sheriff is going to charge us 5%, whether it's a $500 bond or a $100,000 bond. I don't know how it's harder to count $100,000 than it is $50, but Your Honor, the issue is going to be the detention of an individual based solely on the ability to come up with property. I will tell you, I've tried and I've talked to a lot of people. I've talked to everybody in her family.
Okay. Do you have anything else to present on the bond? Were you going to ask the mom to come in? I mean, I think I'm good with what we have thus far.
She is ready, willing, and available. She's next door in the office, Your Honor. I don't have her here because we'll have the whole Zoom back and forth, but I can have her if the court wishes to hear from her.
I think we've heard from her in the past. We've heard from her, I think her father. I don't know if we've heard from more witnesses. So with respect to the bond, again, I don't know if did you have anything else, Mr. Briggs?
No, Judge, I hate that the two of these things seem to be linked, but the bond and the continuance and kind of how we proceed from here, I guess we just need to hear kind of from the court and what the court thinks.
Yeah, so on the bond, I'm not hearing Mr. Benjamin change his, well, let me go backwards because I'm crossing over. With respect to the continuance, I don't hear Mr. Benjamin. I am still hearing that he wants to go to trial on Thursday.
Your Honor, may I clarify that?
Sure.
I apologize. I said I wanted to talk to my client, and I'm doing that at 5 o'clock, and I will notify everybody. Your Honor, and here's my issue. I can talk about a lot of things, but I don't have the legal ability to change that position without my clients.
This is what we're going to do right now. So I am not, if you need more time on the continuance, this is what we're going to do. On the bond, on the continuance, and on everything else, we're simply going to transport your client on Thursday morning. Okay. We'll have her here on Thursday. The bond is going to be 50,000 cash surety, 50,000 PR. The PR conditions are going to be exactly what the previous PR conditions are, because I believe we had, I don't know why I feel Mr. Briggs was on this, or somebody told me about the GPS monitor, and I had accepted the alcohol monitor. She's got to have that before she's released, Brock. So I don't know time-wise that really helps us. Okay. If getting the alcohol monitor is going to be what is utilized, so get to work on that.
Is that an interlock, Your Honor?
No, it's a portable monitoring device that has GPS capabilities. I don't believe the
Understood.
the reporting.
Judge, I'm sorry to interrupt, but we had we've had some bond hearings on another defendant on a case that I'm handling that's a capital murder case, and we contacted PR Bonds about this whole monitoring thing. It was my understanding that they do have ankle monitoring.
Yeah, see, I feel like you've told me that before, and that's why that's in this order, which is
because Judge, and I'll tell you, it relates to Arlene Pena's case. She's the co-defendant of Facundo Chavez, who's we got charged with the death penalty. And when we were doing her bond hearings, we looked into that with PR, And I know that we represent to the court that they have those and that we asked and
Okay.
were granted that as a condition if she gets
Okay.
out.
Then that's going to be the condition. We're not going to accept a separate monitor. So if they can set her up, that's going to be fine. It's going to be 50-50. And the PR bond will be the same. No contact with co-defendant, no contact with decedent's family, once a week, night of curfew, possess no weapons or ammo. I think I'm understanding she's going to live with mom, right, Brock?
That's where she's going to live in an apartment complex currently is where she's at. Yes, Your Honor.
Okay, so she's going to be ordered to live there, may not leave El Paso County. So in terms of a bond, that's where we are.
Your Honor, may I ask for one clarification, one modification?
What?
Clarification, Your Honor. If there is no, and I appreciate Mr. Briggs has intimate contact with PR bond on the GPS monitors, but if there is not, is the alternative this alcohol device, Your Honor? Or does PR have, I'm just curious where we're at.
I'll say yes, but only in the event they cannot set her up with the GPS one. So it's not like, well, we're going to use this instead. No.
Your Honor, I have no objection to that. I've run short of a device once federally, and so that was my concern. So the second question, Your Honor, is if pretrial has the ability to authorize her travel to Houston, or if I need to come back for a court for that, because I have a witness and it's Michelle Phillips. It's not a secret. There's a subpoena outstanding. And it's an individual that I want my client to go knock on the door of.
Yeah, well, I'm not real comfortable with her taking off, so no.
I wasn't going to use the term taken off, Your Honor. She's going to locate it.
Leaving El Paso County.
sure
I don't
would.
want her leaving El Paso County. If she's out and she can help you in some other way, do a Zoom, I don't know, phone call, whatever it takes. I don't want her leaving.
Understood, Your Honor.
So Judge, I understand that Mr. Benjamin doesn't get to make the decision on behalf of his client with regard to weighing in on the continuance, but when are we going to come back and revisit that?
So here was my thought. I mean, I was looking at the calendar and I was thinking we could try and bring her back tomorrow, but that's why I need to know who has jail slots tomorrow, because I need to be asking for their time.
Your Honor, if I could represent, I'm going to talk to my client. I'm going to notify everybody where we're at. I mean, I would assume I can fairly represent, we'll have an answer by 8 a.m. tomorrow, one way or the other, if that makes the parties in the court easier.
So here's the thing. I'm going to order you to have an answer to us by 8 a.m. tomorrow morning. So we're not unclear. Okay.
Understood.
Because I have other things to handle these jury panels too. So.
Your Honor, my jury consultant, otherwise known as my boss, is asking if the jury sheets are going to come out tonight or if they're going to come out tomorrow.
I thought they had already gone out. Have we not sent them to him, Chewy? I thought we sent them out right before lunch.
I sent them to the other parties, Judge, but I can forward them to.
Oh yeah, these folks need to have them too.
Yes, ma'am.
Yeah, and so so on that note, there was another matter. Is there anything else before we get to that?
Just that, Judge, if I could, Mr. Benjamin, I've told you about the state's offer. You know what it is. You know a little bit about our discussions with Mr. Senesi. You know what that deal looks like. You might want to, I don't know, explore a couple things with your client. Maybe let me know if that makes any difference. You know what I'm talking about.
Appreciate the legal advice, Mr. Briggs.
Well, I'd appreciate it. Maybe
You're fine. You're fine.
I'd appreciate if you go ahead, maybe lay that groundwork and find out.
Understood, sir.
Okay.
Okay. So, and don't forget, Mr. Briggs, in the event that we're not at an agreement and we're going to trial on Thursday, we need to have that notice sent.
Okay. Judge, we'll send that notice out tomorrow, regardless of what we hear back from Mr. Benjamin. We'll get it out.
Okay. What's up, bro?
Co-counsel had something, Your Honor. He was piping in.
Your Honor, I do apologize. When I made my entry, I made it under the old cause number. For housekeeping purposes, do you want me to refile on entry of appearance, or can
No, I think we carried everything over. I think we carried everything over. So, okay. What else? Anything else before I tell you about the panels? Okay. So, on another note, I think we had been operating in this case for sure, because I think you all were the reason I had the panels, or at least I thought I had. And don't freak out, doesn't mean we don't have any panels, okay? But initially, I think I had represented that we had 3 panels, 2 on the 10th and 1 on the 9th, whereas I had requested 4 in total, meaning the 9th and the 10th, 4 panels. Through an error with Council of Judges, we lost the December 9th morning panel. It's kind of gonna be a long, but whatever, story explanation. So we had afternoon of the 9th and 2 on the 10th. So I was pretty happy with that, because then I can't remember if it was at the end of last week, we gained the morning panel of December 9th. Okay, so I was very happy, because now I was like 4 panels, and I actually have 2 cases that need to go. And if you guys could go with 2 panels, great. And I could give my other case 2 panels, bring in a visiting judge. We'd have 2 trials going. All right. I came in this morning and was advised that jury hall made a mistake and did not get us the afternoon panel on the 10th like we had been told we received. Okay. So I'm back to 3 panels, but for your scheduling, that means we have a panel December 9th a.m., December 9th p.m., and December 10th a.m. Okay. So we're back to 3, but it's not the 3 that we thought we had. Now we have this one in the morning on the 9th. What that means also, and so you all are aware, the count that we have right now from jury hall is that panel the morning, Thursday morning, only has 27 people on it. Okay. And then in the afternoon on the 9th, there are 53. And then on the morning of the 10th, we have 54. Okay. So I was not happy at all this morning when I found that out, but that's what we have, and I needed to let you all know that.
I'm sorry, Judge, did you say 54 on that last panel? 54, okay.
Yeah, and so just so as an FYI, there's no real consistency in what we're seeing on these panels, okay? I don't know if because that morning panel on the 9th was requested by a misdemeanor court, maybe they requested less, but we are seeing huge fluctuations in the responses we get. Just FYI, that's what we have. Just wanted to make sure you all were aware.
So then I should be keeping my eyes peeled for jury sheets for 134. We'll get all of them together.
Yes, and they are separated by panel. So you'll see panel AM for the 9th, panel PM for the 9th, and panel AM for the 10th.
Okay.
Okay, so I'm gonna look forward to your response, Mr. Benjamin, in the morning.
Will do, Your Honor.
We'll go from there. Kind of make yourselves available tomorrow in the afternoon in case we need to do a quick Zoom, okay?
Understood,
I'm
Your
not
Honor.
scheduling it, but just a lot of things happen.
And Your Honor, the plan is for all 3 panels to be used in this case, correct?
So as we are now, God, Scott, you would have a good question.
Sorry, Your Honor.
Are you all requesting all 3 panels?
For this case, Your Honor, yes. We had all been on board with the idea that we didn't think 150 was sufficient, and Mr. Briggs's math has got us at 134, I think.
Yeah.
So,
I'm not gonna lie, I am actually pretty good at math. That is 134, but no, Judge, yeah, and I took 4 quarters of calculus. I have no idea why. I have a poli-sci degree. I don't know why in the world I had 4 quarters of calculus. But anyway, 134, we ought to be able to pick a jury out of that. But Judge, if you're going to try and pick, another, I don't know how you divide that up to try and do another voir dire in another case. And I know that there's another case set. I'm not that familiar with what's going on with it. So I don't know what the court's plan is with that. If we're going to go to trial on Thursday on this, we're probably going to need to talk to all 134. On the 9th, we're going to talk to 80 people. Is it possible? It's possible, but I don't have a good feeling about that. I'll bet that we end up using the panel in the morning on the 10th as well.
You
But
know,
I've never picked a jury in your court, Judge, so I don't have a good feel
well,
for.
we had one before COVID where I don't know how many we had in the ceremonial court. I don't think it was 80.
Yeah.
Mr. Pop. All right.
Because normally, Judge, I have a pretty good feel for which judges like to just excuse people willy-nilly and which ones don't. And I don't know if you go in the willy-nilly pile or if you go in the don't pile. So
I don't
this-
go in the
this would be a learning
willy-nilly.
experience.
I'm not going to say I go in the willy-nilly. I think, well, I'll look at it. I'll
Okay.
need your response, Mr. Benjamin. In terms of the continuance, that to me is still outstanding. Okay.
Okay, thank you, Judge. I'm glad to hear that because I really do have concerns about trying to rush this thing, just even from the state side of things.
I
Mr. Benjamin's issues.
I don't like to signal stuff, but this is substantively much more of a concern to me than the issues that I heard on Friday. I'm going to tell you that. Okay.
Right.
All right. We'll hear from you in the morning, Brock. And like I said, it's our civil day tomorrow. So it will be difficult. We'd have to do something without your client being here, Brock, if you're agreeable to that, because I just don't think I can scramble up the jail like that. I won't do that. But.
Understood. Your Honor.
All right.
I will be in contact.
Okay. We'll see y'all tomorrow, probably.
Thank you.
Bye-bye. All right. Anything else, Chewy?
No, Judge, that takes care of the afternoon docket.
All right.
Thank you very much, Your Honor. Have a wonderful night.
Good to see you.